What to look out for when dealing with unenforceable contracts. What kinds of contracts might not hold up in court? Because a contract is a legally binding agreement, you and the other party are both expected to meet the conditions of the contract after you enter into one with another person or firm. However, it is possible for a contract that is otherwise lawful to be found unenforceable in the eyes of the law, and this article examines some common scenarios when this may occur. Lack of capacity. Both, or all, parties to a contract should be able to grasp exactly what they're agreeing to. If it shows that one party lacked this ability for thinking, the contract may be declared unenforceable against that person. When one party to a contract is too young or lacks the mental capacity to fully comprehend the arrangement and its repercussions, the problem of capacity to contract arises. The overall goal is to protect someone who lacks the ability to make a rational decision from being used by someone who is unscrupulous. Duress. When someone was threatened into making a contract, duress or coercion will invalidate the agreement. A shipper, Company A, agreed to convey a particular amount of Company B's products, which would be used in a significant development project, under duress. Company A refused to continue the voyage unless Company B agreed to pay a greater price once Company B's project was begun and Company A's ship was en route with the goods. Company B was forced to pay the exorbitant amount since there was no other way to obtain the material, and failing to finish the task would result in unsustainable losses. Because the agreement to raise the price was reached under pressure, the court determined that it was unenforceable. Blackmail is another prominent manifestation of duress. Undue influence. If Person B used a special or particularly persuasive relationship with Person A to force Person A to engage into an agreement, the ensuing contract may be declared unenforceable on the grounds of undue influence. Person A would have to show that Person B used excessive pressure against Person A during the bargaining process, and that Person A was overly susceptible to the pressure tactics for whatever reason, or that Person B used a confidential relationship to exert pressure on Person A to prove undue influence. Misrepresentation. Any contract that results from fraud or deceit during the negotiation process will very certainly be declared unenforceable. The goal is to promote fair and honest negotiations and transactions. Misrepresentations are common when a party says something false, for example, telling a potential buyer that a house is termite-free when it isn't, or conceals or misrepresents a situation in some other way, for example, concealing evidence of structural damage in a house's foundation with paint or a specific placement of furniture. Non-disclosure. When someone fails to disclose a critical detail about the contract, non-disclosure is effectively misrepresentation by silence. Courts evaluate a number of factors when determining whether a party had a responsibility to disclose information, but they also consider whether the other party had or should have had easy access to the same information. It's worth noting that parties are only required to reveal material facts. However, if party A directly inquires about a fact, material or non-material, party B owes it to party A to tell the truth. A lawsuit for breach of contract may be initiated when contract problems entail dishonest practices such as deception or non-disclosure, and one party of the agreement has already experienced financial losses as a result. Unconscionability. Unconscionability refers to a contract term or something inherent in or about the agreement that was so startlingly unfair that it could not be permitted to remain. Again, the goal is to maintain justice, so a judge will look at whether one side has a significantly disproportionate bargaining power, whether one party had trouble grasping the agreement's provisions due to language or literacy issues, for example, or whether the provisions themselves were unfair, such as exorbitant arbitration fees. See Nallo's article Arbitration Clauses in Contracts for further information. If a court finds a contract to be unconscionable, it has options other than just nullifying it. It could, for example, choose to enforce the contract's conscionable sections, while rewriting the unconscionable provision or clause. Public policy. Contracts can be declared unenforceable on public policy reasons, not only to protect one of the parties involved, but also because the contract's terms potentially harm society as a whole. A court will never enforce a contract that promotes something that is already unlawful under state or federal law, for example, a contract for the sale of illegal marijuana, or an agreement that offends public sensibilities, contracts involving some sort of sexual immorality, for example. Other contracts or contract clauses that are unenforceable because they violate public policy include an employer pressuring a worker to sign a contract prohibiting them from joining a union. An employer pressuring an employee to sign a contract that prohibits them from taking medical leave. A landlord requiring a renter to sign a contract prohibiting the use of medically essential companion animals like seeing-eye dogs, and contracts for child custody in California are void if the terms are not in the best interests of the child. Mistake. A contract may be unenforceable not because one party acted in bad faith on purpose, but because one party, called a unilateral mistake, or both parties made a mistake, called a mutual mistake. In either situation, the blunder had to be related to the contract in some way, and it had to have had a major, large, impact on the exchange or negotiation process. Impossibility. In some situations, a contract is considered unenforceable because carrying out its provisions would be impossible or impractical, for example, because it would be too complex or expensive. To prove impossible, you'd have to demonstrate that you are unable to fulfill the contract's performance due to an unforeseen circumstance that is not your fault. The contract didn't stipulate that you have to bear the risk of an unforeseen event, and it will be much more difficult or expensive to complete the deal now. For example, if Company A agrees to sell 20 barrels of flour to Company B, but a natural calamity destroys Company A's entire store of flour before the sale can be completed, Company A may be entitled to have the contract declared unenforceable due to impossibility.